Welcome to the Digital Planning Podcast. This series is designed to educate individuals about all things digital in connection with estate planning, business planning, and estate administration. To keep up with all things digital, please subscribe at iTunes, Stitcher, Google Play, or wherever you download your podcasts. And now, Jennifer Ziegel, a partner at Kleinbart LLC, Ross Bruck, a principal of Estate Genie, and Justin Brown, a partner at Pepper Hamilton LLP, with today's topic.
Welcome to the Digital Planning Podcast. This is Justin, and I'm here today with my co-hosts, Jen and Ross, and we are thrilled to have Hope Comiskey with us to discuss some of the digital issues that people are now facing working at home in light of the COVID-19 pandemic. Hope is the General Counsel at Pepper Hamilton LLP. She focuses her practice on employment law, and she's a fellow of the College of Labor and Employment Lawyers. Hope, welcome to the Digital Planning Podcast.
Thank you very much. It's a pleasure to be here.
So Hope, before we get started, can you tell us a little bit about yourself?
Well, as you said, Justin, I'm a partner in the Labor and Employment Group at Pepper Hamilton. But for purposes of this podcast, I have a lot of time that I spend in risk management and professional responsibility functions at the firm. I'm the general counsel at the firm. I've been in that position for, about 3 years now. And before that, I was the professional responsibility counsel who was responsible for answering the ethical issues provided by the lawyers in the firm. And since there are hundreds of them, it was a very interesting job and continues to be. We give real-time advice. We do educational programs, such as this one, but in-house, and also for members of the public, and we also try to engage in proactive initiatives. In that regard, I'm a member of the Philadelphia Bar Association Professional Guidance Committee. I was co-chair of that committee on 2 different occasions, and I'm a member of the Pennsylvania Bar Association Committee for Legal Ethics and Professional Responsibility. And both of those committees meet regularly to try to answer questions of the association members in the area of ethics.
So Hope, with the COVID-19 pandemic, people are working remotely, they're working from home, and are there any particular rules of professional conduct that people should be considering and keeping in mind as they're working remotely?
Yes, there are 3 key rules on this. And interestingly enough, the first one is the very first rule of professional conduct, Rule 1.1 on competence. And it provides that a lawyer shall provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. As it relates to what we're talking about today, Comment 8 specifically provides that to maintain this knowledge and skill, a lawyer should keep abreast of changes in the law and its practice, including the benefits and risks associated with relevant technology. The second rule is Rule 1.6, which is the confidentiality rule. Subpart A talks about the scope of what's covered when you talk about confidentiality of information, and it says that a lawyer shall not reveal information relating to the representation of a client unless the lawyer is authorized. So it's a very broad scope of confidential information. A few years ago, Subpart D was added. It's a relatively new part to this rule, and again, it specifically relates to what we're talking about today. Subpart D states a lawyer shall make reasonable efforts to prevent the inadvertent or unauthorized disclosure of or unauthorized access to information relating to the representation of a client. And there are 2 comments that follow in the rule that talk about first disclosure obligations and then access obligations. And with respect to the disclosure, comment 25 includes the following wording, that there is no violation of Rule 1.6 if the lawyer has made reasonable efforts to prevent the access or disclosure. Factors to be considered, and then it lists them. One is the sensitivity of the information. Another is the likelihood of disclosure if additional safeguards are not employed, the cost of employing additional safeguards, the difficulty of implementing the safeguards, and the extent to which the safeguards adversely affect the lawyer's ability to represent clients, for example, by making a device excessively difficult to use. And in weighing those factors, a fact finder can determine whether the lawyer's efforts were reasonable in a way that would satisfy the obligations to limit unauthorized disclosure. And comment 26 talks about access and has basically the same language, that the lawyer must take reasonable precautions to prevent the information from coming into the hands of unintended recipients. And again, talks about a series of factors, which includes the sensitivity of the information and also the extent to which the privacy of the communication is protected by law or by a confidentiality agreement. For example, if it's protected by HIPAA because of confidential health information. And the last rule I would like to mention is Rule 5.1, which is the rule on responsibilities of partners, managers, and supervisory lawyers. So if you're a manager in a law firm, under Rule 5.1a, you must make reasonable efforts to ensure that the firm has in effect measures giving reasonable assurance that all lawyers in the firm conform to the rules of professional conduct, and particularly the two rules I just mentioned. Under Rule 5.1b, a direct supervisor of a lawyer has the identical responsibilities to make sure that the lawyers that they're supervising conform to the rules of professional conduct. And if you do not do what you're supposed to do, subpart C will hold you responsible, particularly if you're a manager or supervisor who orders specific conduct that is in violation of the rules, ratifies the conduct, or knows of the conduct at a time when its consequences can be avoided or mitigated, but fails to take reasonable remedial action.
Hope, thank you very much for the background on those rules. Obviously, they were drafted with a different set of circumstances in mind. It should have incorporated the idea that attorneys don't always work from home, but now in this environment where everyone is working from home and technology is more important than ever, can you provide some real-world example of how these rules have become an issue or how technology is impacting the use of an application of these rules in today's COVID lockdown situation?
Sure. Let me just give you a few examples. With respect to confidentiality, there are many issues with privacy. Just people are working from home and their family is there. And the lawyer may be sharing a computer with a spouse or a partner, and they have to make sure that the data that they're using on client-related matters is not accessible by the partner or other person. And there also may be children sharing the computer. And you have to be very careful on how the computer is used in order to maintain these obligations under the rules of professional conduct. With respect to security and inadvertent access or disclosure, we've seen a lot of connectivity issues. Connections to the internet may not be secure, or they can't support the demand given the current circumstances. And so there are lots of issues with confidentiality and competence in connection with confidentiality. One that's gotten a lot of attention is video conferencing. And you may have read about a problem that's been referred to as Zoom bombing, where uninvited attendees of meetings that are scheduled through video conferencing come in and disrupt the meetings and in some circumstances share shocking content. I'll give you two examples that were contained in an article from the New York Times from March 20th, but then updated about a week ago on April 7th. Chipotle was forced to end a public Zoom chat that the brand had co-hosted with a particular musician after one participant began broadcasting pornography to the attendees, and there were hundreds of them. Another example was that two journalists, Kara Swisher, who actually was a contributing writer for the opinion section of the New York Times, and Jessica Lessin, hosted a Zoom event focused on the challenges women tech founders face. They were forced to abruptly end the event after just 15 minutes of conversation because a participant began broadcasting a video with shocking content. And in addition, the FBI has issued a warning. They issued it on March 30th about what they refer to as teleconference hijacking, which is similar to what I just described, where it's referred to as Zoom bombing.
Thank you, Hope. Can you tell us your thoughts about voice-activated listening devices that people may have at home, such as Alexa or Siri or Apple Home, and how that could be impacting or violating privacy and confidentiality rules when talking with clients, if those devices are present in an office or in the room where any conversations or communications are taking place?
They're very, very risky. In fact, our advice is to disable any such smart speakers or devices. Anecdotally, someone told me a story where they were having a client communication, and in the back, I don't know if it was Alexa or one of her cousins, but one of those devices just started speaking out loud, and it was a conference call. People were on speaker, and the attendees could hear that. We also know that there are recordings that are done by these smart devices, and it may ultimately, we'll have to see how the case law goes, but it might ultimately lead to an issue as to whether the attorney-client privilege has been waived because the information has communicated to a third party without a need to know.
Are there any programs or ways to opt out of transmission of recordings through these voice-activated devices to third parties?
I'm not a tech expert, but you can disable the device. And that's the advice that I've seen documented many times in this environment.
Now, on a related topic, what about any type of just general privacy issues with using smartphones?
I haven't seen anything different in terms of the use of smartphones as opposed to the use of a computer with video and voice capability. I think it's the same issues. The smartphones, because they're transportable, there are other issues that aren't just in connection with working from home. You can be, I don't know if we're traveling now, but if you were traveling on a train and you're talking on a cell phone, obviously there's more of an opportunity for people to overhear those communications. If you're at home and you're working in a private room or a room with the door that's closed or a different floor from anybody else in your home, it's less likely to have those kinds of consequences.
Hope, on a related subject, in a recent podcast, we were talking with one of our guests on the subject of remote notarization. And this is a fairly new field, especially for some states that have not previously permitted it. But in most instances, for remote notarization, the act and the signing needs to be recorded between the signer and the notary. I imagine there are instances where a attorney could be involved. What do you think attorneys should be concerned about when recording video between a notary, the signer, who is probably their client, and if the attorney is involved in that conversation or in that process?
This is really cutting edge because there are I think there are 20-some states now that have approved this type of remote notary functionality, and I think New Jersey this past week just passed a statute on that. My suggestion, it's just kind of my gut reaction because I don't have any experience on it yet, is that you should make sure that you use a provider of a service that is going to allow you to accomplish that has security features that you want. Just like Zoom or video conferencing have to have certain security features, those kinds of software applications that will allow you to engage in these notary functions remotely should have those same kinds of security functions. I'm not a tech person. I can't tell you exactly what they are, but I do know that our firm now is examining several providers for that specific purpose in order to allow our lawyers to provide those services, particularly in New Jersey where any lawyer can notarize a document, but to do it in a way that is safe and secure.
Hope, what should non-lawyers who are employed by firms be thinking about when they are working remotely? Are there any rules that they need to abide by?
Well, it's interesting. Firms may have confidentiality policies or work from home policies, but in terms of the rules of professional conduct, they only apply to the lawyers. But there is a specific rule, Rule 5.3, that talks about the lawyer's responsibilities, again, in managing and supervising non-lawyers. And Rule 5.3 basically says that it's the lawyer's responsibility to make reasonable efforts to ensure that the firm has, in effect, measures giving reasonable assurance that the person's conduct, the non-lawyer's conduct, is compatible with the professional obligations of the lawyer. And so there's a lot of wiggle room in here. There are a lot of reasonable in this requirement in Rule 5.3A and B. But the lawyers have an obligation to make sure that the confidentiality obligations, the security obligations, the competence obligations that belong to them are actually being understood by the non-lawyers. So simple things to do on that is, send emails, just reminding folks, you have to go in if you're using anything for the firm, you have to go in through a firm connection. Work in a room with a door that you can close if possible. Don't post anything that's work-related on social media. We actually just sent around a little what we call professional responsibility reminder to everybody in the firm with just tips like that to remind particularly the non-lawyers of their continuing obligations to maintain the confidentiality of the matters that they're working on, even though they're working on those matters from home.
So, Hope, if I'm a lawyer supervising a paralegal or my secretary, I can do those things that you mentioned, but how do I practically supervise the day-to-day tasks that they're doing, right? It's not like I can go into their office and see what they're doing, or if they have a question, they can just come to my office and ask me a question. How do I supervise them if I'm in my home and they're in their home?
Well, what we're doing is, and I think the answer is different for every discipline, depending on what your support folks are being asked to do. What we're doing is we're checking in on a daily basis with those who are supporting the professional responsibility functions at Pepper, and we're also engaging in weekly calls. They're actually video conference calls where we go over what people are working on, what their workload is, whether they have any time to take on more work, and whether they've been assisting others. I think the more communication like that, the better it is, and the more likely you'll be able to supervise those individuals correctly. If they're doing any drafts for you, sometimes, my assistant, for example, will draft a cover letter. If I were in the office, I'd be reviewing it. I just say, please send it to me before it goes out, or cover an email is a better example. Please send it to me before it goes out because I want to make sure, I take a look at it. So you have to engage, in my view, in at least as much supervision as you would on a daily basis at work, and probably more because, Justin, as you said, you don't get to actually observe what is happening because of the situation where everybody's working remotely.
Hope, along those lines, do you think there is anything that attorneys and law firms should be considering as best practices or additional things that should be included in their engagement letters to potentially authorize, video communications with clients, or anything related to COVID-19 about permissions for communications to be done at home, and maybe even highlighting that there could be some issues with confidentiality or outside or unsecured internet usage for email transmissions? Anything along those lines?
I think a firm has to have in place, based on the rules that I just described, electronic means to make sure that the communications are as confidential as possible. So, for example, if you have secretaries or non-lawyers accessing data remotely, they have to be doing that through VPN or a Citrix link up or some other tunnel, so to speak, so that it's a direct communication from their computer right into the firm. You can't have them using, free internet or somebody else's borrowed internet, and that's a responsibility of the law firm. That's not something that a client reasonably should be asked to consent to. You could have, and we have in our standard engagement letter, under our additional terms of engagement, provisions that allow communication by cell phone and communication by smartphone, if it's not a cell phone, some other kind of smart device. And we also have a provision about email communication, and that generally we don't send things in a encrypted format. If the client wants us to do so, we can certainly make arrangements for that. But our normal transition is just through standard email. Those kinds of provisions you can put in, but not the type of provision that would excuse a violation of the rules of professional conduct in terms of reasonable measures to put in place to preserve the confidentiality of the client information.
Sure, and that makes a lot of sense. But what about video conferencing? Is that something that's included in your standard engagement letter? Is that something that firms should be adding to engagement letters to permit communications with clients through that means? And then maybe referencing the host of issues that could come up potentially, through Zoom bombing, even if there are secured passwords and, additional measures taken?
Again, I have to check as to whether our standard language includes video conferencing. I assume that it does because it's not a new functionality. We've been using video conferencing, but certainly it should be included in the standard language. But again, it's up to the law firm and the lawyers to make sure that whatever video conferencing you're using is being done in a way that is secure. There have been changes to the Zoom accounts now where they have a software update that you get a private invitation from the person who's responsible or hosting the meeting, that the host has to let you in. You go into a virtual meeting room, or waiting room rather, and then the host has to actually let you into the meeting. There's a meeting ID that's required, that's a password required for all meetings. If that technology exists, it's the lawyer's obligation to make sure they know about it and to implement it.
On a similar note, all of the technology we're talking about existed before the social distancing was put into place. So when you think about these changes and the world we live in compared to what it was just a few months ago, do you see it as night and day, or is it just a simple evolution of the process of what was already accessible to the attorneys at your firm and elsewhere before? And as a related question, when social distancing winds down in whatever form it will be and whenever that time comes, do you see these same rules being just as important going forward, or do you think about it another way in terms of there will be a cutoff point and a return to normal, quote unquote?
That's an interesting question. I think most of these ways of communicating existed before, but they were often done in a more secure environment. We would do a webinar through our office. We wouldn't be downloading a software application and using it in our personal computer. I think people are using these functionalities much more now, and it's kind of up close and personal, and that's why I think that they're learning more about how to use them, and they're more cognizant of the pluses and minuses to them. They're also, in terms of the example I gave with Zoom bombing, because more people are using it, they're finding more issues with it. And that probably, in terms of going forward, is going to continue. Hackers will find new ways to try to break into your systems or other electronic communications. Once this gets protected and secured in terms of the video conferencing, they're going to look for some other way. And the level of security may even have to increase depending on the type of information you have and you're communicating. For example, particularly in your world, if you're transmitting information with social security numbers or birth dates, that's highly confidential information, and you may even have to be on higher alert. Certainly, if we ever get back to normal, we would have to continue to abide by these rules of professional conduct in terms of the privacy trends with electronic data and level of security. Interestingly, the Pennsylvania Bar Association Committee on Legal Ethics and Professional Responsibility, which I mentioned earlier, where I'm a committee member, issued a formal opinion this week. I think it was issued on Monday. It's Formal Opinion 2020-300, specifically talking about ethical obligations for lawyers working remotely. And it goes over the rules that we discussed, best practices for data security, ways to enhance online data security, including they actually refer to the Microsoft guidelines to users for a secure home office. But these guidelines, a lot of those guidelines came from prior opinions that the Pennsylvania Bar issued on, again, how to be able to have your data secure, how to be able to comply with your requirements for competence and confidentiality in a world where most of our communications now are in electronic form.
I have a quick question related to non-electronic documents then. Obviously, many attorneys and many staff members are working remotely. In the occasion where there is a hard copy of a document, what procedures should attorneys follow in terms of securing those documents until they are back in the office, until they are able to get staff who are able to receive mail or who are able to take it and secure it in the form that it would have been prior to social distancing?
If they're drafts, we should be telling our support folks to put them in a container and return them when they come back to the office if they can't shred them at home. I have a little tiny shredder and it can't really shred a lot of what I'm printing out and reviewing. And so I am keeping all of that information in a Redwell, actually, and it may take me several trips back to the office when I return, but that's how the client confidential information that is in printed form should be handled. It should be maintained separately from your other personal records while you're at home, and it should be returned to your office if you do not have an opportunity or availability to shred it while you're at home. And that also goes to electronic records. Where are those going? A lot of people are creating all these electronic documents, and again, you have to be careful and make sure that you're not saving them onto your private hard drive of your private computer, that you're saving those documents either in the file management system where they should be or remotely on whatever drive is available through work so that you can locate those documents when you get back to work.
Hope, what about executed documents? Jen and I, for example, are practicing estate planning attorneys, and it's quite possible that other estate planning attorneys like us have had will executions during this time period or estate planning document executions. And oftentimes the attorneys are holding those documents in their homes, original documents in their homes, and waiting until they can get back to the office to put them in a vault. What do you suggest that people like us do with those originally signed documents?
That's a very difficult question. I mean, other than putting them someplace secure where no one else can maintain them, it's difficult to know what to advise at this point in time. What you might want to do is scan it if you have a scanner available so that it's at least in electronic form somewhere. I know it's not as good in terms of evidence as the original, but just to show that you did have the signed document in case anything would happen to it. Maybe some other practitioners in your area would have more or a better recommendation on that than I do. That's a difficult situation. What we're seeing in connection with corporate work is that DocuSign is being used more frequently. The electronic software allows you to keep a record of exactly who signed what, and it's all done with an audit trail. And that might be something that you might want to consider using until you can, get back into the office.
Hope, do you have any firsthand experience with stories, maybe with the attorneys that you know or attorneys that you've heard of or read? I know you shared some about the Zoom bombing earlier, but that really deal with and may highlight some of the privacy and confidentiality issues with attorneys working remotely in connection with violating, the rules of ethics.
I personally don't have any of those stories because I'm happy to say that our firm was pretty aggressive in getting the proper hookups for the non-lawyers who are going to be working remotely. And we haven't had any problems of which I'm aware involving any of the things we've talked about. People putting things on private drives when they should be in the client file matter, the Zoom bombing, because we took steps in advance to avoid it. I haven't seen also anything from the Philadelphia Bar. We just had a guidance committee meeting last week, and there are hotline write-ups when people call and ask questions of the person assigned to answer questions for those who are lawyers in Philadelphia County and actually in the surrounding counties as well. And the write-ups, at least for March, they were pretty routine in terms of conflicts and other ethical issues, and there was nothing specific on this point yet. That obviously may change. The longer we work remotely, the more likelihood there is that there will be a problem, but I haven't seen anything like that yet. Although we haven't seen anything personally on this issue, I recently read a report of a situation in Legal Ethics 360, which I think is illustrative. It happened in the UK. It was a firm named Simmons & Simmons. That firm had to post an apology on its official Instagram account. And what happened? An employee's daughter took his phone and did a live broadcast of a dance routine on the firm's Instagram page. Of course, this was not meant for its corporate account, and the firm explained that in its apology and also referred to a whole new world of challenges brought about by our situation with remote working from home, especially where there is family involved.
So as we look to the future, and there will probably be more working from home and remote working that happens as the result of either further quarantines or just change in the norms and change in life. What do you see as trends or other pitfalls that individuals will encounter in working remotely?
As I tried to explain, and I think it was Ross who asked me the question earlier, we've had most of these kinds of forms of communication prior to working remotely. I'm sure there'll be more as we go forward, but the basic problems that you have to look out for are always the same. There always will be issues with privacy. Make sure you can keep the information confidential. And the same trends with respect to the electronic data. There will always be people who are trying to figure out new ways to get access to your confidential information. And you just have to make sure that you are consistent with the competency rule, that you're engaging in education to let you know exactly what you should be doing, that you have the latest software updates on whatever programs that you're using, and you're getting information either from bar associations or elsewhere as to what the best practices are.
Hope, thank you so much for your time today. How can our audience members get in touch with you if they have any further questions?
I'd be happy to answer questions. Folks can reach me at my Pepper Law email, which is my last name and first initial, miskih@pepperlaw.com.
Thanks, Hope. And thank you for listening to this episode of the Digital Planning Podcast. Stay safe, and we'll see you next time.
Thank you for listening to this episode of the Digital Planning Podcast, the podcast designed to educate individuals about all things digital in connection with estate planning, business planning, and estate administration. Please subscribe to this podcast and leave us a rating or review at iTunes, Stitcher, Google Play, or wherever you download your podcasts. Thanks for joining us. We'll see you next time.
This podcast is not intended nor should be relied upon as legal advice, nor is it creating any attorney-client relationship with a listener and the hosts or guests. The information provided is only for educational and informational purposes, and the information provided will likely change.